iPhone 13 on us for every customer. Current, new, everyone. To show the love.
How about sushi?
I just had sushi for lunch yesterday.
How about tacos?
Automatic emergency braking, one of 6 advanced safety features standard on every 2022 Chevy Equinox. Find new technology. Find new roads. Chevrolet.
Welcome to the Black Table, an hour devoted to exploring ideas and subjects of special interest to African people and to others fighting to build a better society. I'm your host, Greg Carr, here on the Black Star Network, and as always, very honored to join you. And we decided to devote today's episode of the Black Table to a discussion of the recent Supreme Court ruling in Dobbs versus Jackson's Women's Health Organization. And we are joined by our regular legal roundtable, Professor Angela Porter, professor at American University School of Law, and Dr. Valethia Watkins, professor at Howard University. And we are going to go through the Dobbs case, see how it relates to other cases that the Supreme Court has heard in its recent docket. And we'll talk about some of those cases. We'll talk about the implications of overruling 50 years of precedent in the wake of Roe versus Wade, and how this is about a woman's right to choose. And it's also about a right to privacy that the Supreme Court of the United States says doesn't exist in the federal Constitution. So welcome, Professors Porter and Watkins, back to the Black Table.
Thank you.
Thanks
Glad to be here.
With great pleasure. So let's get right into it. Of course, people have been talking about this case since the draft opinion was leaked, which of course caused John Roberts, the Chief Justice, great consternation. He's got a whole-scale investigation. Maybe Clarence Thomas and his wife will come up as they're looking for who leaked the document. But we've been talking about this for several months, and the decision we anticipated would come down. Would either of you like to start out for our audience and for all of us trying to understand what this case is and what it means? Let's talk a little bit about Dobbs versus Jackson. So either one of you, please lead out. What is it, and what is the ruling? What is the ruling, and what does it mean?
Well, I think I'll start. Dr. Watkins, I suppose I'll start. I just think we cannot overstate the destructive power of this opinion. I think we went through some of the mechanics of it during our last conversation with you, Dr. Carr.
Yes.
But this time around, we have the concurrences, we have the dissent to round out exactly what's going on. And I think when you read through those things, the reality, the social reality of this decision really sets in. This is about raw power. It is going to have an impact. It's going to have an impact on women. It's going to have an impact on Black people as a whole, as an entire community, Black families, because it's Black families who raise Black children. So, I just want to start there and saying that this is going to have some serious ripples in our life, and we have stepped into a new reality here.
Thank you, Professor Porter, for laying that out and giving us a kind of broad scope on where Jackson versus Dobbs versus Jackson kind of evokes these larger issues we'll be coming back to. Professor Watkins, as we think about Dobbs versus Jackson, there's been a lot of commentary since the decision came down about this not being just about abortion or a woman's right to choose. In particular, there's been a lot of discussion around the right to privacy and whether or not the Supreme Court of the United States even thinks that there is such a thing as a right of privacy. Is that overstating the implication of their ruling? I mean, where does the right to privacy fit in this?
No, it's not overstating the fact that the court has opened the door through its rationale for overturning Roe versus Wade. Particularly, we see it in Clarence Thomas' dissent. They've opened the door that they're going to reconsider the right to privacy in the context of the right to contraceptive, the right to contraception, the right to same-sex marriage, the right to private, intimate conduct. All of these rights were rooted in the same kind of substantive due process logic that undergirded Roe v. Wade and the Casey case. So there is a danger, a foreseeable consequence of what they're doing. This court is very extreme, very radical, and hyper-partisan. And so it is opening the door to overturning these things that we have taken for granted as rights because of the logic they use to overturn Dobbs.
And let's talk about that.
I mean, not overturn Dobbs, overturn Roe.
Yeah, let's talk about that. See, nod your head, Professor Porter. You know, because I know you all talk regularly about this, and there were a lot of concurrences. I know you said dissent. I know you meant concurrence, but I know that actually gives us an opportunity in terms of Clarence Thomas, Lethea. But this gives us an opportunity for folks who aren't court watchers, who don't use this language a lot. You know, a couple of things. Were there, in you all's minds, to your knowledge, an inordinate number of concurrences in these opinions? And what does it mean when a justice concurs? In other words, I'm gonna vote with you, but I have a little bit different take on this. So we know Clarence Thomas concurred in Dobbs, but we also know that he voted ultimately with the majority. So yeah, I'm with you, but I need to write separately. What does it mean when a justice writes separately, either to concur or to write separately in dissent? And how does that play into the logic of what we see here in Dobbs? Go ahead.
Well, let's just give an overview of this opinion for an example.
Please.
So this was a 6-3 opinion. This again is the supermajority, as Dr. Watkins said, the radical conservative court.
And help us, because a lot of Supreme Court decisions are 9-0 or 8-1. We saw some in this docket. What is a supermajority? It's 6-3. People say, well, what's a supermajority?
Yeah, there's 9 justices on the court. So 5-4 is the majority. 6-3, when you have 6 conservative justices and 3 liberal justices, that's the supermajority. It's hard to overcome that majority. And as we've seen this term, most of the consequential decisions that people care about have been along party lines, 6-3, which makes this court seem rather partisan, which takes away from the legitimacy of the court as a neutral, arbiter.
Thank you.
So this decision was 6-3. The overturning of Roe and Casey is actually 5-4 in this decision. So
interesting. For those who aren't, they're thinking about Roe, but Casey is Casey versus Planned Parenthood, Pennsylvania.
Planned Parenthood v. Casey, which reiterated Roe in a way. It made some changes, but it reiterated Roe. It honored Roe. So the opinion to overturn Roe and Casey was 5-4. You had the conservative justices. You had Alito, Clarence Thomas, you had Gorsuch, you had Amy Coney Barrett, and you had Brett Kavanaugh. Chief Justice Roberts wrote an opinion on his own. He concurred only in the judgment. So what that means is he agrees with the result, which was that Mississippi's law banning abortion after 15 weeks was okay. But he did not agree with the rationale. He didn't agree with the overturning Roe and Casey. I'm sure we'll come back to that because Dr. Watkins and I have more to say about him. But
that's a key point, though. That's a key point.
Yeah, it's a key point. He was like, no, I'd rather hang back and just focus on this opinion. I'm not going to go as far as to overturn Roe and Casey. So he wrote a concurrence in the judgment only. Brett Kavanaugh and Justice Thomas, they wrote concurrences, but they agreed with the main opinion. They just had more to say. They had more to say. They wanted to write their own. They didn't want to write their collective one that Alito wrote on behalf of the majority.
Now, I know we're going to talk more about Thomas, but we haven't heard much about Kavanaugh's concurrence. Is there anything in Kavanaugh's concurrence that you found disturbing?
Yes. Ignorant, disingenuous, ignorant, not smart. Those are the things I take away from Kavanaugh's opinion. He went out of his way to say, this is about judicial neutrality and the democratic process. And it was just so disingenuous. That's all I can say. It was, there's no neutrality.
He's defending his country. Like when Roberts and Amy Coney Barrett ran to Florida to make sure George Bush won the election of 2000. They're defending this fantasy. So that actually is consistent. Plus they don't mind lying as we see them under oath.
It's a fantasy they don't believe in at their heart of heart. It's disingenuous. So he talks about the democratic process, knowing full well, because he sat on the same court that wrote opinions dismantling that democratic process in the voting cases. So he knows that that's not real. He knows that this is an ideological opinion, not a neutral opinion. He knows that they've gone against judicial restraint. So, that's Kavanaugh. I don't know what he's trying to do other than look like something he's not.
Well, it's cynical trolling is what it is.
Wow.
Because they're on one level trying to rhetorically cover their track. No, right to privacy is not implicated. So he's trying to add more meat to what Alito said when they're trying to say, well, Dobbs is different. Abortion is different in terms of right of privacy than these other cases. So it's a false distinction that they're trying to lay out to say we're not thinking about these other things. But in fact, they've opened the door, and Clarence Thomas and his concurrence was just laying it on the line. And so just like Roberts was concerned with appearances, he is in agreement with them in terms of the outcome. He is just as ideologically driven, but he wants to package it in a way to show deference to appearance and to kill these precedents with 1,000 cuts. So he wanted to preserve the legitimacy of the court, and basically, stated differently, hoodwink the public, because he wants the outcome, but to give the appearance that they're not fully overturning Roe when they would have been in effect or in practice.
Right. He's in favor of a slower death.
Excellent, excellent. In fact, this is a good place to pause. We're going to pause here, take our regular first break. And when we return, we're going to continue this. We're going to continue in this vein, thinking about the implications of Dobbs v. Jackson. And we'll be back in a moment here at the Black Table. Pay attention to these advertisers. Support the Black Star Network. You see, this is a conversation you're not going to see anywhere else. Back in a moment.
Love our new Alexa.
It's a Buick.
Yeah, Alexa.
Buick.
Alexa.
It's a Buick.
It's an Alexa. It's a Buick. It's an Alexa. Coach, that's a Buick. That's an Alexa.
The Buick Enclave with available Alexa built in.
Pull up a chair. Take your seat. The Black Table with me, Dr. Greg Carr, here on the Black Star Network. Every week, we'll take a deeper dive into the world we're living in. Join the conversation only on the Black Star Network.
Verizon just gave us all a brand new iPhone 13.
We've been customers for years.
I thought new phones were for new customers.
We got iPhone 13s too, switched to Verizon 2 minutes ago.
Ours were busted, and we still got a shiny new one.
Check it out. So wait, everybody gets the same great deal.
I think that's the point.
iPhone 13 on us for every customer. Current, new, everyone. On any unlimited plan, starting at just $35. All on the network more people rely on.
Welcome back to the Black Star Network's Black Table. We're here at the Black Table with our regular legal round table, Professors Angela Porter and Valencia Watkins. And when we left, you all really put front and center this issue of legitimacy of the courts. And there are those, and I think about some friends and comrades on the left, as Gerald Horne might say, our friends on the left, who will say, none of this matters. It's just words. I don't know why we're talking about these legal opinions. They're going to do what they want. But let's just get it where the rubber meets the road. If you want to terminate a pregnancy now in Texas or Mississippi or some of these places where they've moved immediately, whether it be trigger laws or whether there be new legislation imposed, are women in these states now under the threat and perhaps even the reality of not being able to terminate a pregnancy? Is that the implication of this case? And the other question that I would put along with that is, in New York State or in Illinois, is there any potential, should, for example, the White Nationalist Party recover the federal legislature in the midterms and then perhaps the presidency 2 years later, is there a possibility of a nationwide abort abortion ban, because the argument they make, of course, in Dobbs is, oh no, this is just returning it to the states. Could y'all say something about either of those things? Can you terminate a pregnancy, and could there be a national ban? Go right ahead, Prof. Go ahead, Professor Ford.
Yes. The short answer is yes to both. So I'll focus on the second part of your question, though, about the national ban. In this opinion, the justices were very careful to avoid saying we're returning this right to the states. They said we are returning it to the people and their representatives.
Thank you.
They said we're returning it to the democratic process. And so what that tells me and all of us is that they fully contemplate with this opinion the potential for a congressional ban, a federal congressional ban.
So you don't need a constitutional ban. This could be passed through the House, passed through the Senate, signed by the president. How would that then affect, say, lawsuits that would say the state of New York or the state of California want to be able to have this right because no right against it exists in the Constitution? Couldn't they make that opposite argument?
Yeah, I think it tracks the argument that you just said. Once we have a federal statute,
yes,
the states have to fall in line or they are violating federal law. And that does pave the way for a lot of lawsuits, a lot of enforcement for people just trying to make those decisions that should be private to their own lives. So yeah, we're very close to this reality. Couple that with voter suppression.
I just want to pursue this just for a second. So Kathy Hochul, the governor of New York, they called the special session of the New York State Legislature. They're passing legislation, I think they've already passed it, that will enshrine that right to choose. You're saying if there a national federal ban is put in place, that would trump that state, right?
Well, we are now dealing with federalism and the contours of federal law versus state law. And I think what the main issue with all of this is there are question marks now. And I think that's the true damage.
Mm-hmm.
If you are just a person, a woman, someone who is pregnant, thinking, or someone who is even back up before pregnancy, someone who is thinking about having sex. Now you have all these questions about what am I going to be able to do if things go wrong? What am I going to be able to do if my contraception method fails? Am I going to have this option? And the fact that you don't readily know. So, damn all of the, let's see how federalism works and what's the federal jurisdiction versus the state and what state am I in? All of that legal minutia, let's back up from that for a second. Yes. The fact that you don't know if the answer is yes or no, as a regular person, that is the damage of this case. The fact that you don't know right off the bat what you can do.
Thank you. On the second one, that kind of illuminates. On the first question, whether or not you can terminate a pregnancy in some of these states, you've introduced some other things, Professor Porter, and I wondered, Dr. Watkins, if you have anything to say about this as well, because again, Clarence Thomas previews other rights, such as, or non-rights, potentially, such as the right to contraception. Could it be, as you say, whether you're worried about whether or not your contraception method works, may you not even have access to contraception in the first place in some of these states?
I know it seems unthinkable to people that they're going to ban birth control, but get it in your head, just like they overturned Roe, that is on the table because of their conception of life beginning at conception. This implicates contraception, which may kill life after it is, coming together with the egg and the sperm, but also it really implicates the medical intervention to help people to have children through IVF and other.
Well, how does it do that?
Because of embryos, excessive embryos that are created, and that they're all not used. They create a maybe 12, but they implant 8. And so what happens to the other ones? And so that is implicated. The ability to have medical intervention to help you have children if you're having difficulty. but also the implication is already here. I mean, I am deeply disturbed by the outcome of this case, but the lack of legal notice. As soon as that case came out, some states like Missouri immediately put in a ban. So we have in the headlines the case of a 10-year-old child that is a rape victim in Ohio who was denied the ability to terminate that pregnancy. And so she had to cross state lines to go to Indiana to receive the medical services she needed. Who can even say a 10-year-old body can handle producing a child? And so these radical laws that don't even have any compassion to deal with victims of rape, victims of incest. So the foreseeable harm and damage that they are doing to real women's lives, the potential that they're going to criminalize women who have abortion, no matter what they say to the opposite, because they know that it's so offensive to even think about that. They are giving disclaimers that, oh, we're not thinking about going after women who do this. But if you look at the Texas law, it creates a vigilante system. So the amount of surveillance that women are going to be under, and it's not just women, anybody who helps a person, the Uber driver, the mother. So it's really isolating a person in a situation that they can't even necessarily trust their doctor not to be a snitch and turn them in. They can't trust, not that they can't trust, but if they tell their family members, in some of these states, if family members help them, provide money, help them transport them to another state, some states are considering laws that are so extreme that will prevent people from traveling to other states for these services. So if you're in Texas, they may put in place a law that you cannot travel. Absolutely. So imagine a country where as a citizen, you can't even, as a woman, you can't leave the state. Then also people who have miscarriages, they're going to come under surveillance. So this is an extremely damaging decision. And then on the flip side, they're pro-life until you are out of the womb. And then these same people oppose healthcare, oppose expanding Medicaid, oppose for medical services under the Obama law. They oppose childcare. They oppose paid medical leave. These are the same people that would not vote for the child tax credit that the Biden administration passed to extend it. So there's a lot of cruelty. Well, and for some, it seems like cruelty is the point.
Absolutely, absolutely, and we'll continue this in the third segment. But for now, I want to go back, not go back, continue in this vein, Professor Porter. Like you said, getting beyond the kind of legal ramifications and the language of the law, but you evoked the word federalism. And Dr. Watkins, when you said that some of these states are trying to prevent women from traveling and coming back, I know we all saw that article. I think there was an abortion clinic in St. Louis. And of course, Missouri is really rabid with this. They have already transferred a great deal of their operation across state lines into neighboring Illinois. Mm-hmm. Do you all anticipate a real, to borrow this language very specifically, war between the states? Because some of what you're describing almost is eerily reminiscent to the 1850s and the fugitive slave law and the Underground Railroad. Is that overburdening that comparison, or is there really going to be a fight now break out between states over this? Go ahead, Prof.
Well, I think it's very much in line with what you're evoking, going back to 1868, well, really even earlier, back to pre-Civil War, because there's a slogan that Trump used, and there's a slogan that Reagan used before him, and that's "Make America Great Again." And this court is doing just that. This court is in that ideology, just like many before them. They're returning to a court that preceded the Warren Court, the Constitutional Revolution. They are dismantling these analyses that allow us to evolve and think of rights that were not expressly outlined in the Constitution. One of those analyses is substantive due process. So yeah, they would love to go back to note their version of pre-Civil War. And I say that because they're really romanticizing their own history. Mm-hmm. Because The history has always included people resisting and fighting back against all of these oppressive forces. The history has included women getting abortions, regardless of what the law says. Law be damned. It's just, what is that going to look like? And are we going to be open enemies with the governing systems that we live under? It looks like it is going to be that situation, very adversarial, very violence-filled battleground. So that's what they're going to have to take along with their return to their romanticized version of history.
Wow.
But it's also infusing a lot of legal uncertainty. There definitely will be contestation between the states. So this is creating more of the conditions for, it's a very dangerous time, because not only do you have hyper-political polarization, but this fight between states, where states are going to try to make laws that extend past their borders, is setting the country up for a real dangerous path to go down.
This is critical. We're going to pause again, and when we come back, I hope we can continue right here and put Dobbs v. Jackson in the context of some of the other decisions that the Supreme Court came down with in the last few months, certainly this last month of June. And when we come back, we're going to look at how these decisions really speak to setting up exactly the type of political objectives that we've heard Professors Porter and Watkins talk about. So we'll be back in a moment here at the Black Table.
Verizon just gave us all a brand new iPhone 13.
We've been customers for years. We got iPhone 13s too. Switched 2 minutes ago, literally right before this.
iPhone 13 on us on any unlimited plan for every customer, with plans starting at just $35. All on the network more people rely on.
Love our new Alexa.
It's a Buick.
Yeah, Alexa.
Buick.
Alexa.
It's a Buick.
It's an Alexa. It's a Buick. It's an Alexa. Coach, that's a Buick. That's an Alexa.
The Buick Enclave with available Alexa built-in.
Welcome back to the Black Table. I'm Greg Carr, honored to be your host here on the Black Star Network, and joined today with our regular legal roundtable participants, Professor Valethia Watkins of Howard University and Professor Angela Porter of American University. So we're back. And in our final segment in a moment, we'll talk about, of course, the swearing in of Ketanji Brown Jackson. I believe your dean was there, Professor Porter, her friend, Roger Fairfax, out there at American. So we'll talk more about that in the final segment, along with some cases that are going to come up in the docket in the fall of this year. But let's talk about Dobbs in the context of some of these other cases, because you all have raised some very important and points as it relates to this overall objective. We know there was, for example, a voting rights case out of North Carolina, Berger versus NAACP. There was First Amendment case, the Kennerly versus the school district, Bremerton School District, the school prayer case. I don't know if there are any of the other cases that surrounded Dobbs in this year's opinions that raised alarm bells for you in terms of enabling this very scenario you all sketched out for us in the second half of our last segment. How does Dobbs fit in the context of some of these other cases we saw decided this term?
Well, think of all the rights that you hold dear and all the things you care about, and just slash them and dash them. I mean, that's what this conservative court is doing. So we could talk about the case involving Miranda rights, or we could talk about the EPA case that came down the last day of the docket. I mean, all of the big issues that you care about, right, particularly as Black people, that we care about, voting rights, this court is going after them. And let me just really quick explain how law works and how the states work. Mm-hmm. This court, through Dobbs and through these other cases, has issued a clarion call to not only the states, conservative states, but conservative attorneys, lower court judges, I mean, Thomas's concurrence does just this. He says we're going to, and we should go after contraception. We should go after, he doesn't even say same-sex sexual acts. He says private sexual acts. Very broad.
Well, what does that mean? That means you can't do what you want in your bedroom? The police can't just bust in on you in your bedroom. Now, that's just...
It could mean that. It could
no
mean
way.
And he says,
well, they used to do that, so...
In fact, was it Griswold? No, what was the case where they busted in?
Lawrence v. Texas.
Lawrence v. Texas. That's right.
Yes, normally people refer to that as sodomy or same-sex sexual acts, but he did not reference this as such. He said private sexual acts. So he's broadening that
without respect to gender. So really, okay, I got it. Yep. It's almost like and people joke and say, "Oh, the Handmaid's Tale." No, this is like white nationalist Christian theocracy he's talking about.
Right.
Go ahead.
And just to finish that point.
Yes, please.
When the court does that, when it issues its signals.
And that's what you're saying, a concurrence or even a majority opinion, you're signaling to people, these are the kind of lawsuits we might entertain.
Absolutely.
Huh.
So when the court does that, whether it's in a concurrence or in the majority opinion, and they did this before Dobbs, so pay attention.
Yes.
States pass laws that they know are illegal. States pass laws that they know the Supreme Court has previously said are unconstitutional. You might be wondering, why do we even have this Mississippi law about 15 weeks when the court before said the viability line is further along than that? Because this is part of a legal movement. So now what we're going to see is cases involving statutes or laws that states pass that they know are technically illegal under Supreme Court precedent because they know that this court is ready to dismantle all of that. So you don't even have to wait for the next Supreme Court case. It could be tomorrow. It could be next week that the states are pushing the envelope, or that you have these conservative groups creating lawsuits to do just that. So, it's the mechanics of the Supreme Court run really slowly, but because they have essentially signaled, we got y'all, the states can just now do what they want to do. We are in the MAGA playground.
This is critical. Can you raise that? Make America Great Again, from Reagan to Trump to now that slogan. And Dr. Watkins, when you evoke the Texas law, which basically deputizes anybody that wants to stick their nose in somebody's business, I'm thinking about that in terms of puzzle pieces. The New York State Rifle and Pistol Association versus Bruin case, where they basically saying you don't really need to show any particular need to have an open carry permit in New York City. Are we looking at a scenario where this court is trying to, in two things, weaponize those who want to call themselves defenders of the faith, almost in like a birth of a nation thing, wherever they are in the country? Get your pistol in New York, get your pistol in liberal California, go out here. And on the other side, restrain the state, and by the state, I mean the state broadly, whether it be state government, federal government, capacity to intervene, whether it be a 100-year-old plus New York state law, or whether in the EPA case, whether it be the administrative court's ability to constrain polluters or corporations. I mean, what do y'all think this court's ultimate agenda is? It isn't just about red states, blue states, or it doesn't seem that way anyway, listening to you all. Dr. Watkins, do you have any?
Well, the New York case is particularly egregious when it comes back to back when his book ends with Dobbs. So on the one hand, you're saying we're going to return the decision back to the people and their representatives. And so in New York, you're basically throwing away a 108-year-old law that was passed by the legislature, by the people's representative, and basically reading very broadly the ability, the Second Amendment in ways that it really goes against precedent and goes against the history of the Second Amendment. Basically, in the Heller case, they read out the first clause of the Second Amendment, a well-regulated militia, and now saw it as an individual right. And so they have really put into question the ability of states to regulate guns. And so this ability, that the effect of that decision was to say, you can openly carry guns in public spaces. Do we want guns at bars? Do we want guns on the subway, these sensitive places. They have signaled that they are going to very narrowly read the sensitive places, which is ironic, where they are demanding more protection from guns and protests, but as individual Supreme Court justices, they want more protection for themselves. And we look at July 4th, there was just another mass shooting. There were multiple mass shootings on July 4th, but a major one in Highland Park, Illinois. And so we see a gun epidemic.
Before you go on, Professor Watkins,
gun violence.
You lived on the south side of Chicago. You lived in the Hyde Park area, around the corner from where Obama and Farrakhan's and houses. Help people understand, because the popular culture is pushing that this was a Chicago shooting. Could you help us understand the geography of Chicago and how Highland Park isn't Chicago?
Highland Park is a wealthy suburb of that area. And so this area is predominantly white. And it is, people were saying, this doesn't happen here. And that is just such, no one's safe. And so the fact that you would tolerate it happening to other people and hinder law enforcement, hinder state legislatures' ability to regulate these guns. I mean, there's no reason why weapons of war should be on the streets, because when the gun violence happens, the amount of physical damage is beyond repair. And so what does it take? They're shooting up churches. They're shooting up children in school. They're shooting up public places. And yes, it's connected to this larger agenda that they have. And so in reality, what the court is doing is very unpopular, very much challenges their legitimacy, but they don't care. They don't care because they have lifetime tenure, lifetime appointment. They are legislating from the bench, and they're doing something. We need to connect these cases to other cases like the voter rights cases, because they came for that first. They came for those cases first, which then they're making decisions that are going to concentrate power in the hands of the GOP. So we're looking at the danger of white minority rule, meaning the people, the majority, are being, there are constraints that systemic constraints that are being put in place that will shield or immune the court and the GOP from political accountability for what they're doing. And so we're entering a different nation. We're entering a different phase of this society.
Yeah, it's a new reality. And that goes back to when we were talking about Kavanaugh's concurrence. He knows all of what Dr. Watkins just said, even though he's talking about ideals like the democratic process and, the majority is talking about returning this to the people and their representatives. This is the same court that has curtailed voting rights through the earliest VRA cases that we think about to these more recent cases this term, where they
VRA for folks, Voting Rights Act. So this is this just a long attempt to claw back the gains of the 1950s and 60s, the human rights movement, the civil rights movement?
It's Make America Great Again. They're trying to go pre-Warren Court. So when you look at that other case involving Miranda, where they said that now people cannot sue police officers in the civil realm for not giving Miranda warnings. So even though Miranda warnings are still required in criminal cases, otherwise the confession gets thrown out. If the police can't get sued for money damages, they have less incentive to do the right thing. They can be crooked. It's sort of like, I'd be a crooked cop and it's okay. The worst that's going to happen is they throw the confession out and I'm not going to get sued. That case is dismantling all of the ideology around Miranda, which was decided by the Warren Court. Chief Justice Earl Warren decided cases like Brown v. Board, really decided a lot of these substantive due process cases, Loving versus Virginia. So Miranda is one of those cases. So as you say, Dr. Carr, is the 50s and 60s constitutional revolution being dismantled.
Let me ask you this, Professor Porter. We're coming up on our final break, but I want to ask you this because you worked in city prosecutor office. You know what the police side of this looks like. What are the implications of loosening the kind of fear of implications for the 1983 cases or civil cases, what would be the implications of this case, the Vega versus Tika case, the Fourth Amendment case, on these officers on the street?
Right. So that Vega case, yes, that's the case we've been talking about with dismantling Miranda. Again, the worst that can happen is that the confession gets thrown out in that individual case.
Mm-hmm.
So police officers, it sort of says, hey, we got your back if you want to be crooked and if you want to purposely not give Miranda warnings. And for those who don't know, Miranda warnings are those rights you see the cops saying on TV in Law and Order. You have the right to remain silent. You have the right to an attorney. If you can't afford one, we'll give you one. Anything you say can and will be used against you in court. So you're being recorded when you get arrested, audio and video. It just suggests that police can slickly not give you your Miranda warnings and hope that maybe you don't catch that as a constitutional violation and they can go do their trickery. And the worst that happens is, hey, maybe that case doesn't succeed, but they won't individually be punished for it.
So
it's another form of immunity for government misconduct.
For government conduct, that's what I was going. And so both of you possessing the JD and one who's been on a federal clerk a couple of times, different places, and also on the side of the prosecutor, what is your best advice to that woman or man that gets stopped on the street by the police?
Don't say anything.
Don't say anything.
Immediately, well, here it is. Immediately request an attorney. And then after that, don't say anything. Don't gesture. Don't nod. Don't shake your head. Just be like a robot that has been shut down. Don't do anything. You are being recorded from the moment they encounter you. So make sure you have an attorney. Some people think that they can trick the police or they can wiggle out of it, but you don't understand in that moment what the legal elements are of the crime they might creatively charge you with. So you just want to be totally silent.
And I would add, you may want to add, am I free to go? So once they tell you, because sometimes they are detaining you without telling you they're detaining you. And so that may seem like they're just talking to you, but if you just say, am I free to go? And if they say no, then you're being detained. And two, don't ask for your attorney. Don't say nothing else.
This is, and we're going to take a pause here and come back to for our final segment. But so you all, everybody who's watching, this is the broad conceptual universe of the American legal universe distilled down to straight on the street advice at the black table. So let's be clear. All right. Very important. So when we come back in a moment, we're going to look at not only the implications of this current Supreme Court term, but what we might be able to anticipate in the fall, October 2022, when Ketanji Brown Jackson sits for her first cases on the United States Supreme Court. Back at the black table in a moment.
How about sushi?
I just had sushi for lunch yesterday.
How about tacos?
Automatic emergency braking, one of 6 advanced safety features standard on every 2022 Chevy Equinox. Find new technology. Find new roads. Chevrolet.
We're all impacted by the culture, whether we know it or not. From politics to music and entertainment, it's a huge part of our lives, and we're going to talk about it every day right here on The Culture with me, Faraji Muhammad, only on the Black Star Network.
These are the only bins that will accommodate larger overboard.
They put 10 in here?
Yeah, and you don't come out till you die. And you eat every week.
Oh my God.
Love our new Alexa.
It's a Buick.
Yeah, Alexa.
Buick.
Alexa.
It's a Buick.
It's an Alexa. It's a Buick. It's an Alexa. Coach, that's a Buick. That's an Alexa.
The Buick Enclave with available Alexa built-in.
Welcome back to the Black Table. I'm Greg Carr, your host here on the Black Star Network. Thank you for supporting the Black Star Network, and make sure that you all do that and spread the word about this network and all of its shows. We're coming back now with Professors Angela Porter and Valethia Watkins on the current Supreme Court term, and now we want to turn our attention a little bit in this momentum to the fall term. All the cases obviously haven't been announced, but of those that have been announced, there's, of course, the affirmative action case, Students for Fair Admission versus Harvard. We talked about that. And again, this legal roundtable is compelling having you all on because we did a whole show on Ketanji Brown Jackson. And she said she's going to recuse herself, unfortunately. There's Holland versus Bracken, which involves the Indian Child Welfare Act and whether or not Native American children can indeed be adopted in Native American homes, whether that's constitutional or not. There's the Axon versus FTC, the FTC case, again, attacking the administrative state. What can we anticipate going forward, not just for this fall term, fall and spring term, 22-23, but going forward with this court? And how does Ketanji Brown Jackson in either of your minds play into this calculus?
Well, they are certainly not done with taking away rights. And that North Carolina, there's an upcoming North Carolina voting rights case.
Yes.
That's based on this radical fringe theory called the independent state legislature.
Could you talk about, I think that's is it Moore versus Harper? That's out of North Carolina?
Yes, out of North Carolina.
Yeah, talk a little bit about that's please help us with that, Professor.
You know, the really important point is that the state legislatures or state politicians, it's a question of whether they will have power over federal elections. And what they want to do is the ability to rest in the state legislature, which are predominantly, I think about 30 state governments are controlled by Republicans. And so they want to disregard their state constitutions, which have provisions that deal with free and fair election. They want to be able to make new rules about voting that would radically change the entire American electoral process and cut the state judiciary out of the process of reviewing the constitutionality based on their state constitution of the new rules that they set. Are they free and fair, and do they comport with the state constitution? And so this is really radical, it's really fringe, but the court has gestured by taking the case that they're open to that theory. As you say, that Pennsylvania case in this last election where Alito asked for the sequestering of the ballots was, if he had the opportunity, would have done the same thing and basically said it is the state legislature, not the court, that gets to have the final say over the rules. So this is really carrying out the steps that were set in motion with the January 6th coup. And so the wider implication will be that they don't have to follow the popular vote.
Oh, people might have missed it. I mean, as we said before, Roberts and Comey Barrett and Justice Kavanaugh were all lawyers in Florida trying to stop the count in 2000. And maybe there are people who don't remember that Jeb Bush, the sitting governor of Florida, was prepared to give those votes to his brother, and that the Florida legislature was gearing up to go into special session to give those votes to George Bush if the Supreme Court or the state court of Florida, which should have control over state elections, even federal elections in terms of the state law, were going to award those votes to Gore. So are you saying that a state legislature can insert its will over the popular vote in a state in, say, the presidential election of, 2024?
Absolutely. That's what they're teeing up, to carry out those things that they failed to be successful at in this fake big lie about the last election. Except for this time, they're inserting themselves in the machinery of voting to give it the gloss of legality. And so this will set forth so many different rules, so many different new sets of rules, and it's going to control who counts the vote. They get this, and it's a partisan body. It's not a neutral body. The Republicans have an interest of giving themselves an advantage. And so this is about the political maps. So it's not just suppression of the votes. It's not just them infusing these partisan poll watchers who are also people who believe in a big lie. They're targeting every level or every avenue of the voting process. Who counts the vote? Who votes count? And cutting out the state courts and having a role is radically a radical change.
Or Professor Porter, thank you, Professor Watkins. Even when the state courts are involved, we saw the recent ruling in Wisconsin, for example. The Wisconsin Supreme Court, which is controlled by white nationalists, is 4-3 vote, I think it was, opinion, that says that the Democratic governor, Tony Evers, has no recourse when the Republican-controlled state legislature, through hyper gerrymandering, has not affirmed or voted on any of his attempted appointments to state boards, and all of the expired terms of their colleagues and comrades who are in those boards, they can continue in those positions indefinitely. So we're seeing even state Supreme Courts holding this hostage. I mean, what kind of scenario? I mean, Dr. Watkins has kind of laid it out in a broad sense. What do you see unfolding as we look forward to the midterm elections of 22, the president's election of 24, and the Supreme Court decision?
I would totally agree with Dr. Watkins and say, get ready for 2022 and 2024. They have rigged this game, and the court has become a partisan body itself. So it has lost its neutrality, it's lost its legitimacy. We could quibble with whether it was ever neutral, but there's no longer that veneer of judicial restraint. And this is actually one of the critiques from the dissent in the Dobbs case.
That's a good place to end. Wrap this up by helping us understand that. Yes, because the legitimacy of the court, everything's in play now. Please, interrupt, but please make this point.
Well, so all of those cases you outlined, the voting rights cases particularly, to solidify power, but also affirmative action, also just all of these other issues that are coming up, we're going to see them decided along partisan lines, 6-3. Perhaps Chief Justice Roberts will continue to dance his dance, trying
or in the case of Indian sovereignty, you see Gorsuch jumped on the other side, but that's still not enough votes.
Right. You might see one, this is a supermajority, so you might see one of them go to the other side, but they're still going to be able to hold the majority 5-4. And as the dissent outlined, and the dissent was written in this case by Breyer, Sotomayor, and Kagan, nothing has changed over time. The law hasn't changed. The facts haven't changed. Public opinion on these things hasn't changed toward restricting these rights. If anything, it's changed toward expanding these rights. So what they're saying is a big insult for anyone who is a true believer judge, which is the only thing that's changed in this court is the membership.
Wow. Which
means this is purely political.
In the words of Malcolm X, there was no new law. This is all about the personnel, huh?
It's all about the personnel. And so now that branch of government has been compromised, what are we going to do?
What are the solutions? I mean, and I'll ask you both this quickly. I know we're at time, but I got to sneak this one in. Would you, either of you or both of you, be for expanding the court?
Yes. Well, the things that are necessary to redress this really opens the Pandora box, because there needs to be reform. The Republicans pack the court. They keep projecting that onto the Democrats. When you say expand the court, you're trying to restore the balance, because they packed the court with 2 stolen seats, Gorsuch and Barrett. And so we need radical reform to put guardrails back. We need checks and balances. And so it requires that either you got to change, you can expand the court, which is constitutional, and they have done it before, or you need to, and term limits. But if you don't take urgent action to stop this court, because they know that because they're rigging the system politically, you can't do it at the ballot box. If there's no urgent action isn't taken, these people are going to be on the court 30 to 40 years. And this is the same kind of 100-year suppression, oppression that happened after the Reconstruction failed. And so, you know, to save our own political rights, our own humanity, common humanity, this has to be taken on with urgent action.
Well, it's a heavy charge. It's a heavy charge, Professor Watkins. I want to thank you, and I want to thank Professor Porter for joining us again with our legal roundtable. I suspect, and we were talking earlier with Joel and Shannon, our producers here at the Black Table, we're probably going to invite you back sooner than later to try to sketch out what can and must be done and what are some more implications of what's going on now in the courts and how the law is relating to where we are today. But thanks again for doing this, and we will see you again soon. Absolutely. Absolutely. I'll be back in a moment to clear the table and prepare us for our next episode of the Black Table on the Black Star Network.
How about sushi?
I just had sushi for lunch yesterday.
How about tacos?
Automatic emergency braking, one of 6 advanced safety features standard on every 2022 Chevy Equinox. Find new technology. Find new roads. Chevrolet.
It's time to be smart.
Roland Martin's doing this every day.
Oh, no punching! Thank you, Roland Martin, for always giving voice to the issues.
Look for Roland Martin in the whirlwind, to quote Marcus Garvey again.
The video looks phenomenal, so I'm really excited to see it on my big screen.
Support this man, Black Media. He makes sure that our stories are told.
See, this difference between Black Star Network and Black-owned media and something like CNN.
I got to defer to the brilliance of Dr. Carr and to the brilliance of the Black Star Network.
I am rolling with Roland all the way.
Honored to be on a show that you own. A Black man owns the show.
Folks, Black Star Network is here.
I'm real revolutionary right now. Roland was amazing on that.
Stay black. I love y'all.
I can't commend you enough about this platform that you've created for us to be able to share who we are, what we're doing in the world, and the impact that we're having.
Let's be smart. Bring your eyeballs home.
You can't be Black-owned media and be scared. You dig?
Welcome back to the Black Table. I'm Greg Carr here on the Black Star Network. Again, support the Black Star Network. You see why with this conversation we've had over the last hour. And in that vein, Professors Watkins and Professor Porter really sketched out what the trajectory of where the Supreme Court of the United States and those who have enabled it have us headed in the United States of America. Nightmare scenarios potentially. Can a state legislature override the will of the electorate in a federal election? Well, according to that independent state judiciary, state legislator, right, legislative theory, yes, the answer is yes. In the case of Moore versus Harper, if you have a governor and attorney general who has said that a voter ID law is really kind of voter suppression, and while they can't overturn the law, they may not defend it in court. Can members of the White Nationalist Party insert themselves and intervene? The court will say, yes, they can do that. And so what we're seeing is in the almost 250-year trajectory of the settler colony turned country called United States of America, there have been ebbs and flows in the assertion of the rights, to the degree that we can call them rights, of people to assert their ability to shape and control this society. And in those ebbs and flows, we see people with different agendas in conflict. And when we talk about the fact that our democracy is at risk, I would ask, who is we? Who is our? And was it ever a democracy? And the Supreme Court of the United States of America has pushed us again to the brink. And we might ask ourselves, are we in another inflection point? But unlike 1861 to 1865, when it was settled with blood spilled and a whole civil war that created the Reconstruction Amendments. And as you heard Dr. Watkins say, in the wake of the Reconstruction, there was a long clawback against that type of march forward until a civil rights movement made another advance in the opposite direction, and then another 50-year pushback against those rights and expanded rights, including Roe versus Wade, Are we in a moment when if it breaks this time, there's nobody coming to put it back together? Maybe that's an open question. And we'll pursue it, that question and many more here at the Black Table. So we'll see you again next week. Thanks for watching. Tell a friend and support all the shows on the Black Star Network. See you next week.